Joining me is Adam Winkler. He's a professor of constitutional law at the UCLA Law School, also author of Gunfight, The Battle Over the Right to Bear Arms in America. Adam, one of the things that is only being discussed tangentially when we talk about the real differences between President Obama and Mitt Romney looking at the next 4 years is what effect this could have on the Supreme Court, and therefore what is likely in terms of big decisions that the Supreme Court may hear over those 4 years and how that may change and those differences. So let's get into that. What can we expect in terms of the Supreme Court, number one, in terms of the number of justices that the next president will likely appoint, and then number two, what tangible differences this might make? We'll take them one at a time. So first, how many justices might we be looking at?
Well, I think it's almost certain that at least one justice, Ruth Bader Ginsburg, is going to retire in the next presidential term. She's 79 years old. She has pancreatic cancer currently. It's in remission, but it's one of the most deadly forms of cancer. It seems likely that the next president will get to replace her. It's also possible that some of the other justices, Justice Anthony Kennedy and Justice Antonin Scalia, are both in their late 70s. Both seem to be in good health, and so there's no reason to think that they're on their way out. But the way these things work out, the next president should have one, possibly two new appointments to the Supreme Court, which would have a profound effect on American constitutional law.
So let's talk about each of those cases. With Ruth Bader Ginsburg, if President Obama is reelected and he is the one who replaces Ruth Bader Ginsburg, presumably we would be replacing a relatively liberal justice with a relatively liberal justice. It wouldn't necessarily be a net change. However, if it's Romney, that's the one where we could see a change in the dynamics of the Supreme Court. With Scalia, it's kind of the opposite situation. If it's Obama who gets to replace Scalia, we could see a swing there. At the same time, if it's Romney, we may see it continue in that same direction. Kennedy considered more of a swing vote depending on the issue. Is that fair to say?
Yeah, I think that's fair to say. And one of the things we have to remember is while, let's say, President Obama gets to replace Ruth Bader Ginsburg, he would presumably replace her with someone who is also pretty liberal, and it wouldn't have a big effect in the short term. But remember, it would basically lock down that seat for maybe 30 years for a liberal voice. So it would still be expected to have a profound impact long-term on American constitutional law. So you never know how that's going to work out.
Let's talk a little bit about, in those next 4 years, what are likely to be the big decisions that may come before the court, and really let's look at how the makeup of that court could drastically set could set very different precedent moving forward legally.
Well, I think one of the biggest threats to American constitutional law would be if Mitt Romney is elected president, because if Mitt Romney is elected president and he can replace Ruth Bader Ginsburg, all of a sudden you now have a 6-3 conservative majority on the Supreme Court. Again, with Anthony Kennedy, an occasional swing voter who sometimes goes to the left. But him going to the left would not matter anymore once there were 5 very rock-solid conservative votes. So that would have a huge impact on American constitutional law, and we would expect to see quite a number of precedents overturned. Among the big kinds of cases that we're going to hear from the Supreme Court, obviously, the biggest thing is gay marriage. What is the future of gay marriage? Oh, it's only a matter of time before the Supreme Court reaches that issue, may even address it this year. Unlikely, but certainly possible. And the future of affirmative actions on the calendar this year. We have obviously so many of our social and political issues end up in the United States Supreme Court.
If and when, and it seems that it's more an issue of when rather than if, the issue of marriage equality does get to the Supreme Court, on what general basis do you think it's going to be decided? In other words, with the Affordable Care Act or Obamacare, initially there were a couple of fronts on which that could have been decided, and it ended up being that it was decided on the basis of Obamacare as a tax. So when it comes to marriage equality, on what broad constitutional basis is it likely to be considered?
Well, I think there's a couple of ways to address that question. So one possibility is that the court would view marriage equality as just another strand of the fundamental right to marry. The Supreme Court has recognized in a dozen cases or more that there is a fundamental constitutional right to marry. And it could approach the question of gay marriage as just another offshoot of that traditional question of is there a fundamental right to marry? And so it would protect that right in that way. But there are also other ways. So, for instance, the Prop 8 case is coming up potentially before the Supreme Court this term. They may not take it. They may hold it off for a while. That case might be decided on slightly different grounds. The court may decide that there was something unique about the way California operated. In California, we granted same-sex couples the right to marry and then took that right away. The court might reach a positive result in that case in terms of marriage equality, but do so without profoundly changing the marriage rules in all the other states by saying California didn't have the right to offer people this right to marry and then take it away. So there's a couple of different ways. We could see a narrow ruling. We could see a broad ruling. I would expect that over the next 5 to 10 years, we're going to get a broad ruling on marriage equality one way or another.
So I'm going to ask this question in the clearest way that I can. Given a more conservative leading court, which of the various options for how we may get a ruling on marriage equality, which of those options would be more likely to sway a conservative court to further marriage equality?
Well, I'm not sure that a conservative court could be swayed to further the cause of marriage equality.
Okay, so it may not matter on what grounds it's looked at.
Right, well, but it's certainly, one would expect that a more narrow basis would have more potential for a positive ruling. So I know many people in the gay rights community are praying that the Supreme Court does not take the full frontal marriage equality case this year and answer the big question. They'd rather see the court maybe address the Prop 8 case and address it in a very narrow way. People are fearful in the gay rights community that the Supreme Court can't be relied upon to issue the kind of broad ruling accepting marriage equality for all Americans in all 50 states quite yet.
And that's really where the difference could be depending on who the next president is, right? Because if that decision, if the broad decision takes place during the next presidential term, depending on the makeup of the court at that time, we could see drastically different results.
Absolutely. And we could see drastically different results in a variety of other areas of law, too. I mentioned affirmative action. We could talk about women's right to choose is definitely an issue. If the conservatives finally get 6 strong conservative votes on the Supreme Court, it's only a matter of time before Roe versus Wade is chipped away even more than it's already been chipped away. We would also maybe see more strict limits on federal power. Maybe even the court would reconsider its ruling on the Affordable Care Act should the lineup of the justices change.
And what's the legal basis for doing that? In other words, what would have to be the catalyst for the Supreme Court to reconsider something they've already decided on?
Well, they're not going to just reconsider something they've already decided on in such a blatant way, but there are a number of lawsuits that have been filed since the Affordable Care Act challenging a variety of provisions of that law or making different constitutional arguments against it. I don't think those cases have much of a chance of success with this current court. I think this current court feels that they've handled this issue. They don't want to address it again. But should the makeup of the court change, you could imagine the 4 justices who are the most conservative members of the court seeking to accept that case again. And it only takes 4 justices for them to accept a case, an appeal, for them to rule on. So you wouldn't need a majority for the court to rule on it again. You would need, of course, a majority for them to overturn the previous ruling.
All right, Adam Winkler, professor of constitutional law at the UCLA Law School. Check out his book, Gunfight, The Battle Over the Right to Bear Arms in America. Also check out our interview with Adam about that book as well on our YouTube channel. Thanks as always, Adam.
Thanks for having me.
Okay, stay tuned. Plenty more after this.